morning, everybody. It's a great honor to be here again and to talk about the Convention of the Rights of the Child. This year, the topic of my presentation is private law and the Convention on the Rights of the Child and other international legislative instruments that cover the rights of the child. The boundary between private law and public law has been fading for several decades now. On both sides of the former boundary separating those areas, a shared space is growing. This is a space where the legal instruments developed under private law intersect with those of public law. Legislators who try to rationally regulate various issues choose optimal legal tools, and fortunately, in practice, they are not limited in those actions by the framework of traditional academic classifications. This applies to laws concerning human rights. The concept of human rights refers to the relationship between a citizen and the state. The distinctive feature of those rights is that they are subjective in nature and inherent, since they are vested in a person by virtue of the fact that they are human beings. Human rights are not given by a state. The role of the state is to respect human dignity and to implement these rights. There is a correlation between human rights and the obligation of the states. Given such an understanding of human rights, they will not include all requirements formulated by certain social groups, but only those that are grounded in inherent human dignity. In the name of the dignity of a human being, in the provisions of the Convention of the Rights of the Child ceased to be written but condescendingly and treated as an object of adults' influence. Within the earlier framework, documents contained in the formula, we adults give children rights and we give them as many as we see fit. Instead, the Convention adopted a new formula that reads, the right of the child is this and this. Or alternatively, states have the obligation to do this and this for realization of the given right of children. And this shift in the approach is very significant. Children's rights have been dressed in a garb of a legal document. This act is not the source of the rights. It is rather a catalogue of rights. Legal acts do not create children's rights, since their source is an inalienable human dignity. This catalogue was created to articulate and express in writing those rights, to give them statesmen a high rank as possible, to promote them in broad social circles, and ultimately to facilitate their effective enforcement. The catalogues of children's rights, such as a convention, oblige states to create legal acts aimed at guaranteeing the protection of children at a level not lower than that set by a given standard. A standard is a minimum model of legal solution as to specific social relation of a person as a subject of law. In addition to the Convention, various areas of children's rights are addressed in whole or in part in other documents, in particular in the Council of Europe conventions, for example, the European Convention of the Exercise of the Rights of the Child, conventions of the Hague Conference on Private International Law, etc. For further theoretical background, I would like to draw your attention to take volume currently being prepared by the Central European Academy. For now, let us focus on a few concrete examples of how the Convention has influenced the protection of children under private law in practice. The first example is child's right to life. Article 6 prohibits the deprivation of children's lives, which extends to unborn children. The Convention was enacted to protect the child on their rights both before and after birth. The Convention perceives human being as a continuum for conception to death. Human life is a civilized category and as such is protected by private law norms. The provisions of the Convention did not have an impact on the content of civilized regulation of children's lives, but they reinforce the legal position of the child concerning such issues in the area of private law as the determination of the subjectivity of the conceived but unborn child under civil law, protection of personal rights, protection in inheritance law, claim for compensation for damage suffered at the prenatal stage. Second one is the child's right to family. The emphasis placed on the role of parents in the document on the rights of the child is grounded in the view that parents are the people who support, protect, and defend their children. Of course, the Convention also contains regulation to protect children from the danger posed by adults, including parents. This is regulated by Article 19, which refers to public law. Legal issues concerning the parent-child relationship are typically regulated within the framework of parental authority or responsibility exercised by parents, and as such, the issues fall under the domain of private law. Article 18 obliges the state to make every possible effort to fully recognize the principle that both parents share responsibility for upbringing and development of the child. The parents also have the primary responsibility to safeguarding the interest of the child, which is to be the object of their greatest care. The state must also ensure that the child is able to fully and effectively exercise their right under the Convention. Child's right to contact their parents. A child mustn't be separated from their parents against their will, unless deemed necessary by competent authorities subject to judicial supervision in accordance with the applicable law and the applicable procedure for the best interest of the child. The Convention affected the divorce laws. They are formulated to ease tensions between divorcing couples with children, which can be seen in their focus on parental agreement, mediation, and the appointment of an attorney to represent the interests of the child. Those measures enable the child to have a good relationship with both parents after the divorce. The right of the child to establish his or her civil status and identity. From the perspective of private law, especially family law, civil status is the most precise possible definition, a person's family status and their family relations. The issue of civil status registration, including the issuance of civil status certificates, is regulated by public law. However, Issues related to a person's civil status are closely linked to issues falling under private law, particularly family law, since civil status records are issued in the wake of civil law events of a family nature, such as birth, death, marriage, divorce, adoption, and others. A child's identity includes their citizenship, name and family name, civil status, family relations, as well as their religious, cultural, and ethnic affiliation. Convention formulates the right of children to know their rights. As a result, legislators in many countries have replaced the dominant rule of secrecy of adoption with the openness of adoption, especially for the adopted child. Right of the child to information, free expression, and freedom of thought, conscience, and religion. The above-mentioned rights are realized in the parent-child relationship within the framework of parental authority and responsibility exercised by the parents. The child's right to free expression is pedagogically risky, as the torrent of information flooding the child may be destructive. In the Convention, the restriction of the right is allowed only to the extent necessary to prevent demoralization of the child. As for the protection of the right of the child to freedom of thought, conscience, and religion, the Convention explicitly indicates the primary role of the child's parents in this regard. Namely, it formulates the state's obligation to respect the role of parents to provide direction to the child in the exercise of their right in a manner consistent with the evolving capacities of the child. During the process of upbringing, parents are forced to make difficult decisions. On the one hand, to confront the expectations of their children, to place some restrictions on their behavior, and on the other, to show respect for their initiatives. The Convention recognizes this predicament. The child's right to protection of private, family, and domestic life. Article 16 states that children have the right to privacy. The Convention allows parents to interfere with a child's privacy if it is not arbitrary or unlawful. Examples of overreach called arbitrary include invasive monitoring of children's correspondence by parents if it is dictated by their curiosity, or sharing children's images in a way that can be classified as parenting. My last example, right of the child to adoption. The Convention was the first international document to adopt solutions that prioritize domestic adoption over international adoption. The latter is permissible insofar as foster care cannot be provided to the child in any other suitable manner in the country of origin, and to enable the already mentioned right of a child to know their roots. In my opinion, contrary to the best interest of the child and contrary to the regulations of convention is the possibility for same-sex couples to adopt children. In countries that allow for this adoption, the evolution of this procedure came full circle. From adoption, which involved from the ancient adoption in the interest of adults, through the 20th century adoption for the benefit of the child, to the postmodern adoption again established for adults. Ladies and gentlemen, Polish lawyer Professor Tadeusz Smyczyński, who prepared the first draft of the convention, wrote that convention is not the final point in the protection of children's rights, but an impulse to protect them. This is a never-ending endeavor. Yet, this should not discourage us, but inspire us. Thank you for your attention.